Very happy Wednesday to you and welcome to our Elville webinar series. Our topic today is guardianship. What is it? When is it appropriate? And what are some alternatives? And your presenter is our very own managing principal and lead attorney, Stephen Elville. And I'm Jeff Stauffer, Community Relations Director at the firm, and I'll be your moderator today. And a few housekeeping items as we get started, and we always encourage your general questions, so please note them in the questions panel. We'll pause periodically to address them. They always help the presentation immensely. If you have more specific questions related to your individual situation, consultation or discussion with Steve afterwards would probably be more appropriate. And yesterday morning by email, you received the presentation slides that Steve will be referencing, and these materials are also available in the section marked handouts to download at this time. And we have some professionals on today's webinar as well. Welcome to you. For most professionals, 1.5 continuing education hours are available for attendance. And if I don't have your accreditation or an ID number, please send that to me so I can get your hours submitted and certificates sent out. And as always, everyone will also receive a post-webinar feedback email right after the presentation. Please take just a couple minutes to fill this out and share your thoughts with us, and we appreciate every comment that you have for us. So a question for you: have you achieved your planning goals? Or have those goals shifted over the years, which is not out of the ordinary? And here at the firm, we want to be a resource to your family and you for your planning needs. If you're just starting, if you have documents to update, a guardianship matter perhaps, or something else, Steve and our team are here to help and advise you, create solutions for you and a path forward. So I'd like to offer Steve and the firm a brief introduction. We're going to jump right in, have a lot to cover, and appreciate you being here today. So you should be able to see my screen here. Elville & Associates. We were founded in 2010 in Columbia by Stephen Elville. I've been here 11 years, and I'm very proud of that, and hope to retire here at Elville & Associates, provided Steve will have me. We have a lot of different practice areas here at the firm: estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection techniques. We have 9 attorneys, 12 staff members, and 3 locations, including our Columbia location and also our new Rockville location that's at 1700 Rockville Pike, right in the heart of Rockville, as well as our Annapolis location off of Riva Road. And our mission, it's never going to change. It's to provide practical solutions to our clients' needs through counseling, client education, and the use of superior legal technical knowledge. And we focus on education a lot here at the firm. As many of you know, we do it in many different ways. A few of them include through our planning processes with our clients, and process is a very important word. We have different programs here at the firm to suit every individual and family. We also offer many educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only a couple firms in Maryland to have a client care program accredited through the Client Care Academy in Boston. And we're very proud of this program. It is all about planning that works and ensuring that your planning is going to work as intended and stays updated and maintained over time. And lots of nice benefits come with it as well. We also focus on the ideals of client education, collaboration, and compassion with every client here at the firm every day. Just a bit about Steve. Oops. Steve's work as an attorney for many years has been centered in elder law, special needs planning, and estate planning. A member of many different national membership and professional organizations and peer groups, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, along with Wealth Council and many others. Steve works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. And Steve's a very seasoned speaker, presenting at many webinars, workshops for businesses, their employees, conferences, and continuing education events each year. And Steve was named to the Maryland Super Lawyers list for a 9th time, an 8th consecutive year in 2024. So congratulations there, Steve. We'll have the announcements out on December 14th about 2025. I'm pretty confident. And Steve also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I am very fortunate to be a part of. We just had a wonderful, wonderful success story yesterday with the Elville Center. I wish I had more time to jump into it, but it was really just heartwarming about the difference that collaboration with our communities, our clients, interested donors make when we all come together and work towards our great mission at the Elville Center for the Creative Arts. So with all that said, if you want to learn more about the Elville Center, please reach out to me directly and I'll be very happy to share our story with you. For now, we have some guardianship education to provide you. And Steve, I'm going to make you the presenter.
Thank you, Jeff.
And see that button pop up in just a second.
There we go. Our technology is working. Thanks,
Great.
Jeff. And I'm going to get my webinar up there, my slideshow, and get my slideshow started. So let's get that going. And I'm just going to say thank you, Jeff. I'm very humbled by your words and humbled to be here with everyone this morning on this pre-Thanksgiving week. And I just want to wish everyone a wonderful Wednesday and happy Thanksgiving in advance to everyone. And thank you for spending your valuable time on a Wednesday morning with us. And we're going to be very judicious with that time, very efficient. We've begun on time, we're going to end on time, and we want to give you something substantive to walk away from. And I was looking at all those practice areas, Jeff, that you talked about that we are engaged in every day. And I was struck by the fact that many of those are so technical and legal and all of the things that we get into in planning and the changes in the laws and all of the politics and the upheaval in the nation as far as our back and forth about our political dialogue and all the things that affect our lives and planning, not to mention events around the world. But I couldn't think of anything more important as I thought about guardianship and what it means for our attendees this morning, what it means for someone I already spoke to this morning at 8:30 a.m. who's the guardian of their child, the issue of guardianship and what is the best thing, how to approach it, the self-determination of our loved ones with disabilities. What are the alternatives? Nothing could be more important than that. And so it's with great humility that I'm here today to lead this discussion. And I hope that you will ask us questions. Jeff is an expert moderator, has done thousands of these webinars, and he knows how to take your questions. If you're having any technical difficulties and you can't hear us for some reason, please let us know. Otherwise, we're going to launch into the material and I'm going to walk you through a discussion. As I get ready to do that, I hope you will reach for a pad of paper, reach for your tablet, reach for your phone, whatever you use to memorialize notes and write down things that could be very important to you. But of course, you have this webinar material and we want you to use it. We want you to reference it. We want you to feel free to ask questions after this webinar and we can meet face to face. So with that said, this webinar is not legal education, it's not legal advice is what I meant to say. It is just education. So it's not a substitute for legal advice or counseling, which we can do face to face. It is high level education. So let's keep it at that so that you get the most out of it and understand why we're here today. So we're going to learn about guardianship itself. What are the benefits of it? And what are the drawbacks of it? And some of you that are on this webinar this morning, you may know of other people who have obtained guardianship over a loved one with disabilities. You may know some of the pros and cons, or you may be concerned or fearful about it yourself as you think about it. And as we counsel clients on a daily and weekly basis in our firm, we go through these very, very issues. There's not a week that goes by that I'm not sitting with some family that is concerned about the very issues we're going to be talking about this morning. And what are the questions that you should be asking yourself before you launch into a decision to pursue guardianship? What are the alternatives to guardianship and what are the next steps? So let's talk about what guardianship is. Well, guardianship is really the highest form of intervention in the life or over the life of someone with disabilities. So guardianship has to do with an individual having obtained age 18 when they have presumption of legal capacity and they are an adult. And as such, they have the right of self-determination. They have personal rights, okay? So you as parents or loved ones have to make a decision in a typical situation, or if there is such a thing, a prototypical situation of someone growing up, The parents are the natural guardians, and then when that person becomes 18, they are presumed to have legal capacity and be an adult. So if they lack the ability to manage their affairs, a court would appoint a guardian or a conservator. So let's talk about that. There's guardianship of the person. This is the guardianship of a person to determine where they live, what their medical decisions are. And then there's the guardianship of the property, which some states call a conservatorship. So the guardianship of the person is the most common. And that's what this next slide is getting at. So we have guardianship of the person. The guardian has the care, custody, and control and over the education and health and education and welfare of the person. And the guardian of the estate, or guardian of the property, as we would call it, has the obligation to manage the finances of the individual. Now let's talk about who is actually the ultimate guardian. So far we've talked about a person who lacks capacity and they need a guardian for their own protection. We're going to talk about that. And we have a guardian that's appointed. Well, the truth is that guardian is obviously the guardian. There's a guardianship order, which we're going to talk about, that's been issued to give that person the authority over the person with who is considered a ward of the guardianship. But the court is what I would call the ultimate guardian. So the guardian has to account to the court for the guardian of the person responsibilities, that the person is well, that they are where they're living, that their welfare is in good condition, and the person who is the guardian of the property or guardian of the estate, that person has to render an accounting once a year to the court. And there's training about these things. So I just want you to kind of get this visual in your mind of the guardians are appointed or guardian, but the court is the ultimate guardian. So what are the benefits and drawbacks? Well, it's the highest form of intervention. There is nothing higher. The person who becomes a ward in a guardianship, typically they lose their legal rights. So this is the highest form of intervention in someone's life, and that person loses their legal rights. Now, I was in court last week in a guardianship down in Montgomery County. I was watching some of the proceedings, and in one of the proceedings, the parents who were petitioning for guardianship, they said something very common. We want guardianship of our child, but can we preserve that child's right to vote? So you see, there is a general loss of rights, but not the loss of all rights, especially if we ask special permission to preserve the right of that person to be able to vote and so forth. So when I say the loss of rights, it is the general loss of legal rights, but no person loses all their rights. So let's be clear about that. So guardianship is cumbersome. There's a process. It's expensive. So in an uncontested guardianship, it's less expensive. But in a regular guardianship, it's going to be a contested guardianship. Let's say that's not an uncontested guardianship. It can be quite expensive. There's a loss of flexibility. I spoke to someone this week who told me, we're petitioning for guardianship, and we think we're going to go ahead and get that guardianship. And this happened to be the guardianship of an older adult, okay? It wasn't a younger person. And the guardianship of the older adult was almost getting ready to get into process. And the issue there was that the person wanted to know if they could still do certain things regarding the preservation of assets or the flexibility to do this, this, or this with the person's affairs. And the answer was no. You lose that flexibility, generally speaking, once the person gets involved in a guardianship proceeding or is under guardianship. So there is a loss of flexibility. And one of the reasons for that is court oversight. So the court becomes, again, the ultimate guardian. The court wants to know that the guardian's funds are being used for their benefit, and generally speaking, does not allow a lot of legal strategies that are sometimes used in elder care type situations or special needs situations to preserve assets. So there is a loss of flexibility, but that loss of flexibility is due to the court oversight and the annual reporting that has to happen. So no situation is the same, but I'm just going to go through some questions here that I recommend you ask yourself before pursuing a guardianship. Is my loved one lacking the mental capacity to appreciate the nature of their decision making? So let's go over that again. That's a mouthful. Is my loved one lacking the mental capacity to appreciate the nature of decision making? And this is a big issue for parents, especially parents with disabled children who they feel are borderline on this issue. So this causes a lot of emotional angst. It's, I do not have a special needs child of my own, for example, but I've dealt with thousands of cases dealing with these things, and I know the pain that is involved in these kinds of decisions, especially if it's not clear cut. So the next question I ask some parents, especially when it's very difficult to come to a conclusion, is this issue of vulnerability. Is my loved one vulnerable? And many times the answer is going to be yes. This loved one is vulnerable. So to me, that's another indicator that perhaps a guardianship is the right choice. We're going to keep going here. Third question, does my loved one need protection? Obviously, if they're vulnerable, they do need protection. So this is a little bit of a different question, but a related question. Have I explored, and now we're going to get into the other part of this presentation. Have I explored other options, lesser restrictive alternatives, as lawyers say, to guardianship? So have I looked at all those things? And could my situation be settled by way of one of these lesser restrictive guardianship alternatives? Or if I'm in the middle of a guardianship proceeding, can I just settle this thing? Because remember, if you're in the middle of a guardianship proceeding, the guardianship process is adversarial. So you are, not surprisingly, taking a position, as strange as this sounds, against your loved one or against the person who you are pursuing guardianship over, because this is really the taking away of their legal rights in a general sense. So can this be settled? Let's go to the next slide.
Hey there, Steve. Can we pause for a brief question?
Yes, go, please.
So question is, when you say appoints a guardian, is this always in the singular, one guardian, or could it be 1 to 2 people?
Thank you for that question and for just generally getting that process started of questions. The answer is it can be more than one person. It can be 2 persons. I met with a family the other day. There were actually 3 guardians. There were the 2 parents and 1 of the children. So it depends on what the judge deems appropriate. And the idea there was that the 2 parents and that other healthy and well child were the co-guardians. And I think that gave them a lot of assurance that there was going to be a succession plan there after the parents passing. So thank you for that question. Yes, there can be more than 1.
Okay, thank you, Steve.
Thank you, Jeff. Okay, so let's talk about substitutes for guardianship, okay? So remember, guardianship is the most restrictive alternative, and we're going to get into the process here and then get to those substitutes. So the process of guardianship is not going to be plain vanilla. It's not going to always be as clear cut as I'm getting ready to tell you. But if you have a piece of paper, I'd like you to draw a line left to right. And over here, you're going to start this process of guardianship, and we're going to end up over here on the right. And as you start the process, you're going to have 2 physician statements. You have to have 2 physician statements of incapacity. The court issues these forms. These forms are much different than they were when I was a young lawyer. These forms can be completed by doctors, which I highly recommend, but there are also other types of professionals that can fill out these forms. Once we have those 2 forms, we have to file. Your loved one with disabilities or the alleged disabled person is going to be appointed a court-appointed attorney, and that court-appointed attorney is really to advocate for them. There's a change in the law that happened about 15 years ago where this person has to provide the kind of advocacy that would be provided for a person who didn't have disabilities. And the idea is that the right of self-determination of the person, the alleged disabled person, has to be respected. Then there is a show cause order issue. So this is a funny term of art. The show cause order is issued that says, does anyone have any objections? People have to be notified. The proper interested parties have to be notified. So people who would have inherited if there was a death, God forbid, of the person who is alleged to be disabled, if they had no will, who would inherit their assets. Those are basically the persons who have to receive notice. And if the person is under age 70, it has to be the Department of Social Services. If they are over age 70, it has to be the Department of Aging. And it also has to be notified to Social Security. So once these people are notified, if there are no objections, there will be a process leading to a guardianship hearing or a show cause hearing, as we would call it, and eventually a full-fledged guardianship would be awarded. If there are objections, then physicians might have to be called in. There might have to be a jury trial. There might have to be discovery. And that's why a contested guardianship is much more expensive. Ultimately, the contested guardianship is going to go to a trial if it doesn't settle. So there's the difference between a contested guardianship and an uncontested guardianship. So the pitfalls are that, it can be quite upsetting to parents if they get involved in a guardianship process and there's any bump in the road at all. And sometimes even in uncontested guardianships, there could be a little bit of bump in the road here or there. And I just want to say that the emotional awareness, the emotional preparation for a guardianship, even if it's uncontested, it's a good idea just to do a gut check, to have your attorney talk to you about the potential pitfalls. And there usually are not going to be that many, but to at least be aware of those so that emotionally we are ready. In a contested guardianship, we have to be much more emotionally prepared, much more ready for the bumps in the road that will surely come and the financial costs. So we have to be aware of these things. Now, in an adult guardianship, we do not have the luxury of having a supported decision maker to help make decisions, even though Maryland law says it can. It says that we're going to get into supported decision making here in the next hour, but Maryland law says that we've gone from no supported decision making law in Maryland to an incredibly expansive, even hard to understand law for many people. It's so broad that it allows supported decision making not only for a person who puts it in writing, but for a person who verbally appoints their supported decision makers or supporters, but even a person under guardianship can have a supporter. However, and there may be attorneys out there that are seeing things I'm not seeing, but I'm certainly not the only authority on this subject, but in the limited number of cases I've seen, the court is reluctant to help appoint a supporter under guardianship, even though the new legislation says so. So I am very dismayed about this, but the court must have its reasons, and they are interpreting the idea that a person can have a supporter even under guardianship. They're interpreting that very narrowly as far as I can tell. Hopefully that will change. Now, what are alternatives to guardianship, having talked through that, okay? Well, obviously, financial powers of attorney and advance medical directives. So these are what we call the normal incapacity planning documents in estate planning on a day-to-day basis. If someone signs or has the mental capacity to appreciate and execute a power of attorney or an advanced medical directive, what are they really doing in the eyes of an attorney? Well, they're obviously giving their agent, because they are the principal, they are giving their agent authority to take care of their affairs. And they are basically giving them authority at a certain time to be able to do these things. But from an underlying legal perspective, they are avoiding guardianship. So when you have a power of attorney and an advanced medical directive, naming agents, if let's say this disabled person had enough mental capacity to be able to have these documents, That is the best way to avoid guardianship, because that person is naming agents to take care of their affairs, and therefore they don't need the protection of a guardianship. Now, the confusion comes, as many of you are aware, when someone has a higher functionality and could arguably sign these powers of attorney and advance directive, but they are otherwise vulnerable to other things because of their vulnerabilities and need for protection. So this is what doesn't help us and makes it more confusing. Number 3, if someone is a joint owner with someone on an account, there's no need for guardianship for the ability to access the funds in that account or to manage that account. If the person is receiving SSI or SSDI or otherwise Social Security, and they have a representative payee under Social Security, there's no need for a guardian. So the court will always take the position that if there is a representative payee, there's no need for a guardianship. Consent agreements. We talked about this. This is where there's a process ongoing in a guardianship that's probably contested, and now the parties settle. That's called a consent agreement. So there's no need for a guardianship where there can be a consent agreement. And then supported decision making, which we're going to talk about a little further. This is the newest and most viable alternative to guardianship that has come about in the last several years. So here's a will-based structure. In a will-based structure, you just to illustrate these incapacity planning documents, the will is the driving force, and that has nothing to do with guardianship, except a person under guardianship would not be allowed to sign a will unless the court approved it. They don't have the legal capacity to sign a will. But let's get out here to the edges on the right and left. The powers of attorney and the advanced medical directives are the substitutes for guardianship, because the person with capacity can name agents and avoid guardianship of their person for the advanced medical directive side of things, the healthcare side, and avoid guardianship of the property with the power of attorney. So let's get into these documents just a little bit further as we get, and then we'll get back to other alternatives to guardianship. So from the point of view of an attorney, and I'm not just talking about me, I'm not just talking about Maryland attorneys or estate planning attorneys. I'm talking about all attorneys in all states that know anything about estate planning or incapacity planning, no matter what level of clients they deal with, whether they are dealing with billionaires in Manhattan or whether they're dealing with the most fundamental issues in another state. The financial power of attorney is arguably the most important of all the documents. So from an estate planning point of view and incapacity planning point of view, to provide flexibility, the financial power of attorney is the most important, because that's where flexibility can be built in. And that's important for all of us, not just those with disabilities. Now, from a global perspective, we need an advanced medical directive that names an agent. We need a financial power of attorney that names an agent to avoid guardianship of the person and guardianship of the property. So as a global subject, we need agents for both. But from a financial flexibility point of view, because you may have heard me early on in the presentation saying that there is a loss of flexibility if a person has a guardian of their property. So if we can avoid guardianship of the property, we can have a lot of flexibility if a person has a very nicely drafted financial power of attorney. So again, all of us should be trying to avoid guardianship in our own lives and in the lives of our loved ones with disability, where this question is on the front burner. We want to look at this and say, can we avoid guardianship without putting the person at risk, without an unreasonable amount of risk, or whatever that risk is that's acceptable to you and to them, because they have the right of self-determination here. They have not gone under a guardianship as a ward of a guardianship that has lost their legal rights. Can we move forward into the future with this idea of no guardianship? With the advanced medical directive, we want the person under that has agents and is avoiding guardianship, we want them to bare minimum name their agents, decide when the agents are going to be effective, also waive HIPAA, all of these important things that are vital when a person is signing an advance directive. They don't have to necessarily make all of their final healthcare decisions, like end of life decisions. They could leave that up to the agent. So for people who are younger or people who are struggling with their capacity, but they still have mental capacity, but find these decisions to be very upsetting, but they still can sign an advance directive and it makes sense to everybody involved, that person can kind of make it efficient and not have to answer all the end of life decisions, especially for a young person that might be upset by such things.
Steve, can we pause for a question?
Yes, yeah, thank you.
All right. Question is, I'm a little confused, and that's okay. Would this all apply for a mentally disabled adult, in quotes, unquote, meaning that the adult at 18 is not quite capable of making their own decisions? Would any of these alternatives need the person's, quote, consent, unquote?
Well, thank you for that wonderful question. If I'm hearing you right, and I hope I am, it is confusing, and you are, probably voicing the same thing many people are saying, especially when we get into this next topic of supported decision making, that this whole thing is very confusing. I think what the whole thrust of this presentation is that, as you're going to see now with supported decision making, there is a shift change in the way that society is thinking at a high level, at a legal level, about the idea of capacity and incapacity. So I think for you as a parent, let's say with a loved one, with a child with mental disabilities, mental health disabilities, whatever they may be, you're probably, just from your question, I'm assuming you're going to pursue guardianship, for example, just based on the little bit that I'm aware of from your question. But what this presentation is posing is that there are other alternatives to guardianship, and just making sure that you're aware of those. And in considering all of these alternatives, it can be very confusing. But there are otherwise, and I'll go back to this other side now, very clear-cut situations where your child is vulnerable, your child has disabilities, your child needs the protection of a guardian. There is no question guardianship could be the right thing. And you and I, for example, or you and your attorney otherwise, might be meeting about this and come to the conclusion it's time to file for guardianship. And that's what guardianship is for. So this is not in any way meant to minimize the importance of guardianship or to say that it's not important. But what we are doing here today is we're juxtaposing the various alternatives. And this is really where society is right now. Is guardianship really necessary, and have we fully considered its alternatives? And I think that when you fully consider these alternatives, it will become clear to you, it probably in a process of discussion or legal counsel, but it will come clear, and you will know exactly what direction, and that direction could very well be just the traditional approach to guardianship, because your child is disabled, vulnerable, and needs the protection of a guardian. So don't have any doubt about that, no matter what I may say in this presentation. All right, let's go. Thanks, Joe.
Can we do one more, Steve?
Yes.
Okay. And briefly, the previous question, the asker said that she now has it and got it. So thanks for that explanation.
Oh, thank you. Thank you. Appreciate it.
Next is for a person.
Go ahead, Jeff.
Next question is for a person with mental illness, such as schizophrenia, and lacks insight to their mental illness. Will an advance directive or a POA allow the guardian to force a hospitalization when needed, or do you need a guardianship for that?
Thank you very much. So again, in this world of mental health issues at a very extreme level like that, the biggest problem we have, and I know your question I think was mainly about guardianship, so I'm going to get back there. When we go outside the purview of guardianship, we are relying on the person signing this advance directive, making you their healthcare agent. And remember, and this is a little bit more confusing, but don't spend too much time on it, Maryland has something called surrogate decision making. So you may very well be the surrogate decision maker of your loved one in order of priority under the law, even if they don't have an advance directive. But let's pretend that they have an advance directive and they've named you. The biggest problem we see with mental health is that, one, that person may forget that they've appointed you. I'm just making that up right now. That person may fire you if they have some kind of an episode or other phase that they're going through. They may fire you, or it could be the effects of their medication. So the biggest problem there is that we can't count on the advance directive sometimes. And by the way, there is a mental health advance directive. So we have the regular advance directive, and then there is something called a mental health advance directive. There is also a mental health advance directive that was put together by a collaborative organization years and years ago when I was a young lawyer that I still will use today sometimes. So if some of you have someone with mental health issues and you're very concerned about, well, we're not going to go the guardianship route, but we want an advance directive for mental health, we will be glad to help you with that. Now, let's get to the other side of your question, which I think was, what happens if I'm under guardianship? Can I force someone? Well, the issue is, yes, it depends on what the guardianship order says. So I would say a qualified yes, depending on the situation that presents itself to the court at the time of the guardianship and the extent of the nature of the guardianship order. It would give you the authority to do that. Outside of the purview of guardianship, once we are trying to force someone like that, like you're describing, the issue is going to be that they could try to fire you and you would have no authority. And because you're not a guardian, you have to get a court order for such things anyway. So it's a complicated question, but I hope I've tried to help there at least a little bit.
Great, thank you, Steve.
Thank you. All right, now, as we are already past the halfway point in the presentation, let's get into supported decision making. So many of you are familiar at this point with supported decision making, which has only been around for a couple of years now, a little bit more than that. Maryland had no good alternative between the person who can execute an advance directive and power of attorney and avoid guardianship because they are appointing what? Agents, and the person who has to have a full-fledged guardianship. There wasn't much in the middle except the ability to file for guardianship and then settle it by way of a consent agreement. So if you're following me, supported decision-making was available in places like Alaska, Texas, Indiana, Wisconsin, DC, Delaware, and other states, but it wasn't in Maryland, and now we have it. We've gone from no alternatives to this massively broad alternative called supported decision-making. This is a tool, and you're going to read about it. You're going to try to wrap your minds around it. You're going to decide whether, as a parent or other loved one, whether this makes sense to you. For some of you, this is going to make perfect sense, and you're going to see this as a tool for your loved one. For some of you, this will make no sense, and you won't be enthusiastic about it, because the whole idea here is to expand the notion of the right of self-determination. So people with disabilities, as we're going to see, now have more rights that are recognized under the law. So it's a tool where a person can be empowered and supported to make their own decisions to whatever extent possible, okay? It doesn't distinguish between levels of disability. It simply says, this is an accommodation for the person. Society, meaning society has to be willing to be supportive to those with disabilities so that whatever they can do, whatever that person may be able to do, that they have the support to do it, and they should be allowed to self-determine. This is going to be something that strikes you as a positive or negative thing. It can be a simple written agreement. Now, the state of Maryland, unlike Indiana and unlike DC and unlike Delaware, chose not to provide forms. So we have developed at Elville & Associates, we have developed supported decision-making form that I recommend you use, but it's also possible under the law for the person with disabilities to say, hey, I'm appointing Susie as my supporter verbally. Now, it is an alternative to guardianship. So what would happen prior to the advent of supported decision-making is that many courts were treating the right of self-determination of the person, the potential alleged disabled person, to be able to be heard in court, because many times the court-appointed attorneys would waive their appearance in court. But through supported decision-making, it gives the judiciary, it gives the judge a tool to make sure that there's more uniformity in this ability to avoid guardianship and all alternatives be on the table. This is why I'm saying to some parents who forge ahead with guardianship that you just have to get yourself emotionally ready. You have to get yourself emotionally ready for the potential bumps in the road, because society and the judiciary are looking at this issue and saying, we want to make sure that people that don't really need a guardianship are not going under guardianship. And that is the way it was always supposed to be. But now there's other reasons to look at these new laws and say, all right, are we properly applying the idea of guardianship? Now, notice in one of these bullet points about 3/4 of the way down, it says it's a potential addition to the financial power of attorney and medical directive. So we're going to see that in just a second. It's a potential tool in guardianship. Now, this one should have a star beside it because I'm disappointed about this. Obviously, if the law says a person under guardianship may have and can have a supporter, then I think they should be able to have a supporter. But that's not the way the courts are interpreting it as far as I've seen it. It's part of a paradigm shift that comes down from the United Nations mandate on human rights that says people with disabilities now have more rights, more theoretical rights of self-determination even than ever before. So this is a new world of self-determination, and you are going to decide how you feel about this. And so let's get into this a little bit more. There were key players such as Megan Rusiano, who now works at the ARC of the United States, as far as I know. She worked for the ARC of Frederick and other local organizations. And I first met her years ago at a presentation, I would say at least 10 or 12 years ago. Maryland finally passed this legislation. It was long overdue, and I think that it's being widely assimilated into our society, although it is still largely misunderstood by many parents. This is the brief history that I mentioned. There was an old paradigm. How can you understand supported decision-making? I would argue this is the best way to start thinking about it. The old paradigm was protection. We're going to see a slide here in just a second that talks about this. And many of your loved ones do need protection. Do not doubt that whatsoever. But the entire paradigm was about protection. And there was a lot of fear, even among elder law attorneys, about the change that everyone saw coming. So now the question is, do we allow as a society, and do you allow as a parent or loved one, your loved one with disabilities to take more risk and not be under this paradigm of protection? Obviously, if they need protection, that is exactly what should happen. So there was no good alternative. We talked about this. There was no formalized way for persons with disabilities to be supported, even though you've been supporting your loved one for your entire life, and many of your relatives have been doing the same. This is nothing new for you. But as a society, there was no formalized way for people with disabilities to be recognized as needing support to be able to make their own decisions. And one of the reasons this was spurred on is there's no annual review. There is no annual review of private guardianships. Guardianships, if you've ever heard this, are considered permanent, but they really shouldn't be permanent, because if a person is not mentally incapacitated by 2 physician statements, proof of they should not be under a guardianship. So this was a way to start really looking at this issue. So there was inconsistency. We talked about this, old notions of protection possibly no longer needed, and a culture, as I would say, of paternalism. And I don't mean to disrespect any of you who have been protecting and caring for your loved ones your entire lives and sacrificing your entire lives to take care of them. I do not mean to offend you in any way. I'm just saying the entire culture of guardianship was one of paternalism and basically minimizing the ability of a person to take risks and as a result, minimize their potential in theory. So we're going to talk about just on this continuum slide that you're going to see next. And Jeff, I'm looking at my clock and I'm making sure here that we're trying to do what we said, which is end on time. So it's 10:45. Thank you for hanging in there with me. The power of attorney and medical directive, what does it really mean? I, the person who is the principal, the person who signs this, I will make my own decisions, and if I can't, my agents will step into my shoes and do it for me. So I am in control. There is no loss of rights. Now, as you're going to see on the slide, under supported decision making, nothing has changed. I have not given up my rights. I will make my own decisions to whatever extent possible if I have the support to do so. So nothing has changed. But on the guardianship side, this is basically by definition saying, I cannot make my own decisions. I need the protection of a guardian. I might be able to have a supported decision maker, which would expand my rights under guardianship. But again, Maryland, even though it says so, is interpreting this very, very narrowly. Let's look at the slide. So when this first came out, I could not think of a better way to try to explain this to clients and potential clients than to create what I might call the self-determination continuum. So I asked Jeff to create these slides. He did a great job on them. If you look to the left, the person who can execute powers of attorney and advance directives, they are by definition saying they can make their own decisions, but if they can't, someone else will. On the right-hand side, all the way to the right, I cannot make my decisions. I need the protection of a guardian. That is the loss of rights. So we have on the left, no loss of rights. On the right, a loss of rights, except for those the court may still preserve, such as the right to vote or the right to marry. In the middle, we have supported decision-making. I will make my own decisions to whatever extent I can, provided that I have that support to do so. So I just want you to get your minds around this. If you've never seen this, we have an article we can send you. There are other articles. I wrote one early on when supported decision-making was just approved, but there are many other articles. You'll decide how you feel about this as you think about guardianship and alternatives to guardianship. Now, what is supported decision-making not? What is it not? Well, it's not a financial power of attorney. This takes a little bit of getting used to. So if you're confused, everything is normal. Do not beat yourself up. But a supported decision-making agreement is not a financial power of attorney. It is not a way for a third person to make decisions for the disabled person. It is not. It does not give a third person the authority to do whatever they want or deem appropriate for the person with disabilities. And it is not something where the person with disabilities gives up their rights, and it is not guardianship. So what is the difference? Well, in guardianship, and we're being redundant here on purpose to learn, guardianship is the removal of rights of the person and property, the inability of a person to decide where they want to live and their health care and so forth. The guardian would make those decisions. There's no legal choice about most things. Now, that doesn't mean that the guardian should not be a person who's very supportive, obviously. And I think that's what I'm seeing in Maryland cases, the few I've seen. It almost seems as if the court is taking the point of view, if we have a good guardian, why do we need a supporter? Because the guardian is supposed to do all these things in the person's best interest. It's a paradigm of protectionism. That is the guardianship route. Now, I'm not saying again that guardianship is not needed, but there's no recognition of the right of the person to take risks. There's a fear of failure, right? There's no review because there's a private guardianship. There's no annual review, and there's an unspoken but not a technically accurate, but unspoken consensus of permanency. With supported decision-making, remember there's no removal of rights, no loss of rights. There's actually a potential for restoration of rights for someone who's under a guardianship, but never really had the opportunity to have supported decision-making to avoid guardianship. The rights to property and person remain vested in the individual. There's a paradigm of risk, the right to fail. Whatever that little bit of freedom or that little bit of self-determination might be. I've talked about this almost too much, but it can be part of guardianship, although I'm seeing that narrowly interpreted. And it's an addition to a financial power of attorney and an advance directive, even for a person who is older. So we shouldn't exclude from this discussion people that are older or aged. People who are aging should also have a supported decision-making agreement. So, Jeff, it looks like we're true to our word there. I was a little concerned, but I thought I was long-winded, but we are going to be on time and actually have plenty of time for questions. So I'm hoping as you absorb the whirlwind of information I just gave you, I hope what you'll keep in mind is that for people who truly need a guardian, for people who need protection, for people who are vulnerable, you should proceed with the guardianship process and just have both eyes open, have counseling, understand what the process is and the pitfalls, and be ready emotionally and so forth. For those of you who have situations that might be more challenging with potential contested guardianships, we have to be doubly or triply emotionally ready. We have to be financially ready, okay? But there's no way to really know until we review your individual situation. We're here to be resources to you. We are very blessed to be part of the elder law, guardianship, or special needs planning, disability planning community, and to try to be a resource to people who are experiencing these things, families that are experiencing these things every day, day in and day out. So it's a real privilege. We want to give you time to think, space to think, space to evaluate choices. We sit in front of a whiteboard and we work out problems, we work out the challenges, we juxtapose questions, we review your current documents. We try to have you develop a team. Perhaps you need other members on your team, such as a life care manager, such as an advocate, or such as others that we might be able to bring on, such as a financial advisor or CPA. And as today, we love your questions. So we just encourage you that there's nothing to fear if you want to talk about this further. There's an attorney-client relationship. If we actually meet, there's an attorney-client relationship that attaches. Everything is confidential and there's nothing to fear. So we wish you a really wonderful rest of the day on Wednesday and a wonderful holiday season coming up. And whatever situation you're dealing with, whatever questions you have, whatever ambiguities you're dealing with, we are here to try to help you get clarity on those things and approach it at a very high level, and to proceed with guardianship if it's needed, to not proceed with guardianship and take other paths, other alternatives to whatever extent that is appropriate. So thank you for your time and effort this morning. And Jeff, I'm going to turn it over to you to see if there's any more questions, but we certainly are on time this morning. Thank you.
Hey, Steve, thank you for your time and effort. As always, great information. So now, as Steve said, is a great time to get your final questions in, Steve. And as we wait for those, our webinar series moves forward as we go into the holiday season. And we have a few more to mention to you if you're interested. So tomorrow, Dr. Michelle Fritsch, who is a longtime friend of the firm, an amazing nationally known presenter, is going to be talking about health, healing, and low stress through the holidays in our wellness series. So I hope you'll join us for that one. Dr. Fritsch is also coming up for our client care program education event on December 7th, and we're really excited to host her up here. She's coming all the way up from North Carolina to be with us. Also, on December 3rd, learn all there is to know about Elville & Associates client care program, and your presenter is going to be Jeff Stauffer, putting on the presenter hat for the first time and presenting about our client care program, and I'm really looking forward to it. I wish it were tomorrow, so that should be fun. I'll also be moderating it too. So Steve, don't you think I should have a moderator if I'm going to be a presenter?
Jeff, you really should. Now, I don't know who that would be. You are the moderator, so
I'm going to
I
take
guess
care
you
of
could make a video of yourself as moderator. I don't know.
Maybe. I'm going to take care of it. It's going to be a good presentation. Able Accounts, a financial tool to promote health, independence, and financial stability. That's with Kelly Nelson, who is the outreach coordinator with Marilyn Able, also a great friend to the firm. We love Kelly here. She helps so many people and many of our clients. December 4th at 10 o'clock. And to round out the year with Steve, trustee selection and how to choose the right one for you on Friday, December 13th. As Steve has always said, nothing could be more important and critical than choosing the right trustee and how to do that. I will send out the video and the slides again. I'll send out the article that Steve alluded to and some other resources for you as well. And with that said, let's check to see if we have any final questions here. We do. Okay, so a couple here. Question is, if the guardianship is contested, you go to trial, and do you need more documentation? How challenging is it? I'm sorry, how challenging is a contested case, and how early is too early to start planning? My child is 15.
Oh, thank you. Thank you. That is a wonderful question. And I think you don't need to start planning, obviously, more than maybe a year ahead of time. But I do think you need to do some pre-planning there. And it's extremely challenging. I'm not going to sugarcoat it. It's extremely challenging, and it can be extremely upsetting. And you have to, in my experience, you have to form a very strong resolve that once you start the contested guardianship, you're going to follow through with it. Because if it's contested, it could be expensive, it could be heartbreaking, it could be a test of your will. And so all of those things go into it. And I would say plan on a very, very difficult ride there. But if you can weather the storm and you have a legitimate case, you will probably prevail. So I just want you to know that the pain and suffering in the end probably will be worth it in my experience. So my heart, it goes out to you having to even contemplate such a thing, but I would say start about a year ahead of time.
Okay, and thank you. Last question. How early is too early? My child's 15. I feel knowing now is powerful, but do we move now on the options too, or can we only do this at age 18?
Thank you. I think my qualified answer is yes, you could only do this at age 18. The court, even in an uncontested case, the court used to let us start a couple of months ahead of time as far as filing things and then having a guardianship hearing after age 18. But that was even for an uncontested case. For a contested case where it's going to really be tested, and there's going to be a full-fledged show cause hearing and then a full-fledged trial. I don't think there's anything you can do except start, really evaluating about a year ahead of time. What is our information about our child's disabilities? What is, who are the physicians? What would their positions be? And I'd say, 6 months to a year ahead of time, I'd say a year ahead of time, start really evaluating. I don't think there's anything you can do prior to age 18 with regard to the process of legal guardianship that could be contested.
Okay. All right, Steve, those are all the questions. Great ones today.
Thanks, everyone.
Great job to you as always. Thank you. And hope you have a wonderful Thanksgiving, your family and you, and you can find some peace and stillness and be present during this really wonderful time of year. And so happy Thanksgiving, and hope to see you again soon on another edition of the Elville webinar series. And have a great day.